Hello, this is Matt on the Moon Lambo channel. I have two stories to share with you in this very latest Moon Lambo Hot Jam. Starting with this one from the block. SEC's Gerber Gruhl criticizes crypto industry's non-compliance, creative attempts to avoid rules. Now, on this particular topic, I also have the pleasure of sharing with you Ripple's top attorney's response to this, because he just shreds the director from the SEC on this. Because, and this part won't surprise you in the least, what this director at the SEC is stating is a denial of reality. He's living in absolute fantasy land. And now that won't surprise you, but I'm going to highlight it and we're going to smash it to pieces because it's a bunch of crap. That's for damn sure. Then there's also this headline from DC Journal. The SEC came to destroy crypto, not to regulate it. Now, this one will be a pleasure to run through with you. It is written by Rosalind Layton. And she was covering the SEC v. Ripple case basically from the beginning, like right out the gate. And she was writing for Forbes on this topic for years. And I shared every single one of her articles with you. But a few articles ago, at some point, I guess it was last calendar. I want to say it was at some point, maybe it was the first half of 2023. I can't remember exactly, but she had, for the second time, one of her articles, which was published on the Forbes website, it was removed. Now, I don't know what happened. There was clearly some sort of falling out as a result of what she wrote within that article, and she was just railing on Kim Jong-Ginzer, like that, and deservedly so, of course. But her article was taken down from Forbes with no explanation, and then she stopped writing for Forbes. Something went down. And since then, she's been writing for DC Journal, putting out the same quality content that we've come to expect, though. So I'll be running through that as well. But before going further, I do want to be clear. I do not have a financial background of any kind. I am not offering financial advice, and you definitely should not buy or sell anything because of anything I say or write. I'm just an enthusiast who enjoys making YouTube videos about crypto-related topics, but just as a hobby and just for fun. All right, into this first piece. The Securities and Exchange Commission's top enforcer, Gerber Gruhl, condemned the crypto industry over its significant non-compliance, and that's in quotes, and addressed criticism lodged at the agency over the years. Gruhl, the director of the agency's Division of Enforcement, laid into the crypto industry on Wednesday morning for about 15 minutes during a two-day SEC Speaks event. That's the name of the event, SEC Speaks, sponsored by the Practicing Law Institute. And here's a quote from Enforcement Agent Gruhl. Over this past decade, we have confronted significant non-compliance in many, many creative attempts by market participants to avoid our jurisdiction, with some claiming that we're making it up as we go, that we are regulating by enforcement, and others arguing that we are somehow recklessly exceeding our authorities, end quote. And then he noted that his views don't necessarily reflect the agency's. Now, I'm glad he acknowledged that that's how people have been responding to those asshat pricks at the SEC. That's fantastic. That part I'll go ahead and give a thumbs up to. But I got to ask you, if the SEC is actually doing everything right and everyone else in the space is being unreasonable, just tell me, how is this the case that for the first time in humanity, you have every participant in an entire industry, with rare exception, insisting that the SEC is actually regulating by enforcement? And that there is not sufficient clarity on what the rules of the road are. How is it that almost 100% of participants in an entire industry feel exactly the same way and believe that? Why don't we have that type of perspective in other markets that the SEC has legitimate jurisdiction over? Because, to be clear, the SEC doesn't have legitimate jurisdiction over cryptos, broadly speaking, because obviously individual cryptocurrencies aren't securities. But compare it to any sort of a sector where the SEC does have legitimate authority. Why don't we see that there? How are so many people screaming? They're telling the SEC, no, we want to comply. Like, we're here. Tell us what to do. How are there so many people just coming out of the woodwork saying this stuff? And then they just happen to get sued years later. It's just ridiculous, obviously. But anyway, piece continues. The crypto industry has criticized the SEC for what many call regulation by enforcement, while SEC Chair Gary Gensler has argued that most cryptocurrencies are securities and should be regulated similarly to other investments. Cases have been taken to the courts with some firms, such as Coinbase, arguing that crypto is similar to Beanie Babies, and others calling for clarity on how securities laws apply. Gruhl said, the test to determine whether crypto is a security is the Howey test, referring to the 1946 U.S. Supreme Court case frequently cited by the SEC to determine whether an asset qualifies as an investment contract and therefore a security. It's not the essential ingredients test or the Beanie Babies test or some other tests that industry folks might like to create for themselves, Gruhl said on Wednesday. The SEC has been clear and consistent about Howey. There are no secret analyses, Gruhl added. Oh, yes, well, the SEC's obviously been very, very, very clear. Taking multiple positions on all sorts of topics, just in the Ripple case alone. Major hypocrites there. So here's what Stuart Alderati had to say. Stuart Alderati, of course, is Ripple's top in-house lawyer, their chief legal officer. Here's what he wrote on social media platform X just a bit earlier this evening. Director Gruhl says the crypto enforcement unit acts with integrity, but ignores the debt box sanctions for gross abuse of power, the Ripple judgment's admonishment for lack of, quote, faithful allegiance to the law, end quote. And by the way, gross abuse of power, that was from the debt box case. That's an actual quote from the judge as well. And then Stuart Alderati says, and the, quote, arbitrary and capricious, end quote, finding in the grayscale case. That's funny. Isn't it kind of weird how Gerber Gruhl would just leave those out? No, we're the SEC. We're doing everything right and on the up and up. Yet here you have, in case after case, the judge is saying, no, you little punk-ass bitches, you are not. I'm just kind of translating that. And these are just kind of lay terms. Obviously, he's not being intellectually honest here. Really steams my vegetables, son. Mr. Alderati continues. On the substance, he cites one portion of the Ripple ruling but ignores that the SEC lost or gave up on most of its claims in the case, including the court's rejection of the SEC's assertion that XRP was in and of itself a security. And folks, that was obviously the most important part. That's the only part that really, truly, truly mattered, to where if that wasn't a win for Ripple and XRP holders, because it mattered to all of us, it matters to everyone in the ecosystem, that would have been the devastating loss. You know, not that I want the SEC to win on anything in the Ripple lawsuit, but, you know, if there's unfavorable terms regarding the remedies, or if if they choose to appeal and it's not, whatever, if anything goes, okay. I'm not saying that would be good. I'm just saying for us typical XRP holders out here, it's never going to impact us. We won. Anyway, then Alderati says, he says the SEC has given clear crypto guidance, but that guidance, which is still on its website today, adds and subtracts factors to the Howey test at whim, leading to what the agency's former general counsel said was greater confusion. If this agency wants to honestly repair the institutional damage inflicted both to itself and the industry over the last many years in this misguided war on crypto, it needs to get off its soapbox and own up to these truths. Golf clap for Mr. Alderati, everybody. Fantastic. And of course, obviously true. But if the SEC is going to continue to lie, I'm going to continue to highlight it on this channel, because at least I have a platform where I can do so. What a bunch of little baby back biatches. Now this headline from DC Journal: the SEC came to destroy crypto, not to regulate it. That's the damn truth. Again, this is written by Rosalind Layton, who it's literally spent years writing articles shredding Kim Jong-Gensler and the SEC, and she's continuing to do that. Reads as follows. Following the Securities and Exchange Commission's effort to stretch, bend, and twist the law to grant itself authority to regulate cryptocurrencies has been like watching an exhausting video game. By the last level, the monster has grown so grotesque and ridiculous that you're just waiting for the relief of seeing it explode so the comforting words "game over" can finally appear. Of course, I'll just pause and note, usually when "game over" appears, that's when you lose. Just small critique. Anyway, she continues. Unfortunately, it's not a game for many innovative U.S. financial tech companies. The SEC has mobilized all its resources to carry out a policy against crypto companies that is not designed to protect investors from fraud or even to clarify what legal compliance means. It is practicing what Professor J.W. Verrett of George Mason University has called enforcement by destruction, trying to turn courts into execution chambers for an industry it never intended to regulate but to destroy. It comes down to a bait and switch strategy by two successive SEC chairmen to claim that every digital asset, no matter how it is designed, is itself a crypto asset security, and that gives the agency full authority to require they be registered like stocks. Nothing in nearly a century of securities law provides the SEC such all-encompassing authority over an entire asset class. But the SEC's strategy was never to prove this theory in court, so much as to have a pretext to launch enforcement actions never meant to bring anyone into compliance. Reading over the court dockets of SEC non-fraud enforcement actions against crypto companies, the malicious roadmap becomes clear. First, the agency has never issued a single regulatory guideline registering a digital asset or determining whether it will be a security. There are no forms, no instructions, and no published rules for registration. Companies that go to the SEC in good faith to ask for guidance have instead gotten subpoenaed and sued for failing to register despite having no idea how. It has been an exercise in gaslighting, and not one cryptocurrency transaction among billions has ever been registered by the SEC, nor do they ever intend to allow a registration to happen. The SEC's lawsuits seek such huge dollar figures in disgorgement and penalties at the start that companies often see no choice but to fold. The few who decide to fight have exposed how truly bad the SEC's faith has become. And folks, this is where we get to the part where she talks about Ripple and specifically XRP. And I will tell you, and it's just amazing having a front row seat watching this as history unfolds, because this is a case that's going to be studied for decades to come in the legal profession and in universities. And it really truly is as impactful as we in the XRP community believe that it is. I mean, obviously, those involved are going to be paying the most attention and think it's the biggest deal that there could possibly be. But it really is that big a deal in terms of setting the trajectory for what would happen after that for the entire crypto asset class. If this went poorly for Ripple and for XRP holders, whatever other coins you listening hold would have been in serious trouble. So this is a major win, and it just so happens to be directly impacting, first and foremost, people within our community most directly, obviously. And it's just amazing. Out of everyone in crypto, it happened to be our community. Of course, right? Still unbelievable. The cryptocurrency I put the largest individual portion of my money into, and I know it's true for many of you out there, that's the one they attacked leading up to the bull market last cycle. That's the one. Oh, of course. Well, thank you. My God, all I can do is laugh about it now. Because it absolutely has substantially negatively impacted my personal financial well-being and all of you listening as well, of course. I mean, because I can just imagine, had I gotten the life-changing wealth last cycle, which I believe would have occurred because the entire asset class was blown up and XRP would have hit a new all-time high, had I gotten that, I'd be sitting in a different position today. And I'm still happy with where I am broadly speaking in life, for sure, financially speaking. Yes. But I could have then, after the market tanked, taken 10% of those profits, chucked it back in, I'd still be earning money. And then that money, the extra money from my life-changing wealth, that would be invested in other stuff, being preserved, but yet earning money. Maybe in more traditional means. There's all sorts of stuff, in real estate, whatever. I'll never get to have that opportunity now because of them, not for that market cycle. And then if you understand the time value of money, compound interest, then you start to realize just how catastrophic this was. It's not just missing out for that market cycle. It's all of everything that would have happened in subsequent years as a result of reinvesting the money. So it's unfortunate, but I'm not going to have a sour attitude. All I can do is laugh about it at this point. And the truth is, I'm way better off than I would have been had I not jumped into to crypto. I'm way better off financially. And when it comes to stuff like this happening in life, it's okay to acknowledge it and kind of bitch about it a little bit, I suppose. But the truth is, when it comes to stuff like this, it's better to just focus on the stuff in life you can control. and I can control the rest of what I do in crypto. It's just, yeah, you get a roll or like a, you know, a situation like this happening. It's like you can't control it. Just pops up out of nowhere and you never expect it, and it can seem very scary and devastating in the moment. But you just control the parts that you can control. That's how you should approach pretty much anything in life here. But it doesn't make sense to harbor, you know, some sort of resentment that would make you feel miserable on a daily basis. So I'm doing nothing like that. Now, every now and then I am going to bitch about it a little bit, but I'm feeling happy. Like I am thrilled and I'm excited on a day-to-day basis just to be here. That's all I'm saying. Anyway, peace continues, though. The SEC sued Ripple in December 2020, claiming that the XRP token itself was a security, which meant every offer and sale of XRP was an unregistered investment in the company, even on secondary markets between parties that had no knowledge or connection to Ripple. It was a novel legal theory that twisted decades of jurisprudence on securities law. It was clearly designed to give the government enough leverage to force Ripple to close its doors. But in her July 2023 U.S. District Court Judge Annalisa Torres firmly shot it down. It took nearly 3 years, and according to Ripple CEO Brad Garlinghouse, over $100 million in legal costs to get clarity that the XRP token is not a security when offered and sold on public exchanges. Along the way, the SEC was castigated by a magistrate judge for dragging out the case with unnecessarily complicated litigation tactics that lacked a faithful allegiance to the law. Torres found that only one set of $700 million in sales of XRP to institutional investors constituted securities that should have been registered. No fraud was alleged, and none of the investors had lost money or been harmed. However, instead of using the decision to lay out a registration framework for future companies to be compliant with this technicality, the SEC could only chafe at how it impeded its one and only objective: to destroy Ripple. Recently, the SEC dropped all pretenses. It filed a proposed final judgment requiring Ripple to pay $2 billion in disgorgement and penalties for this non-fraud technicality. That is 300% of the value raised by the institutional sales of XRP. The SEC's brief reads like a vengeful diatribe with exhibits that include nearly 30 pages of tweets where retail holders of XRP, the people the agency is allegedly protecting, celebrated Torres' ruling that the token is not a security. And by the way, folks, I did mention it in one video, but one of those tweets in that exhibit, one of those tweets is from me. I am in a document filed by the SEC to Judge Torres. One of my tweets with the Moon Lambo name. What in the ever-loving... Like, what fresh hell is this? How is this real life even? I mean, it's funny, but my God, these asshat pricks. I had some very choice words about them, which I am not comfortable repeating on YouTube here, but I had some choice words about them on social media platform X. And I'll just leave it at that. I'm not going to repeat it here. I'm not thrilled with them. Let's just say that. Anyway, then she wrapped up by writing, as Verrett noted, most final settlements in non-fraud cases in recent years, where a defendant simply failed to register, averaged less than 12% of the original penalties sought by the SEC. Not one of those settlements provided clarity to the markets about how crypto sales can be compliant. However, several companies were destroyed in the process. What other goal could the SEC have with its absurd $2 billion demand other than to destroy Ripple? I'll pause. I'll add one. Also to harm XRP holders, hoping that Ripple will sell. And I talked about that in another video, so I'm not going to in this video. But yeah, hoping to damage the price of XRP and hurt XRP holders. So that also. And then she says, it is encouraging that the courts have been knocking the SEC back in this and many other high-profile cases. However, not every defendant has the resources to fight. Enforcement by destruction wins by attrition more than merit, thanks to the political acquiescence of a government with no qualms with an SEC that actively seeks to destroy capital formation rather than facilitate it. Golf clap for Ross on Layton, everybody. Fantastic article, per usual. And isn't that something? So 300% of what the actual $700 million charge, that's what they want Ripple to pay. But normally it's 12%. 300% versus 12%. Folks, there's no precedent for this. These people are scumbags. I'm not a financial advisor. You should not buy or sell anything because of anything I say, all right? That would be a very, very, very bad idea. Until next time, to the Moon Lambo.